Hello, critical thinkers. We are live. Greetings and salutations. Hope all is well. Tonight, we're going to be going over the latest Robert Brooks and Messiah Nantwi murder cases, legal updates in terms of defendants who appeared in court today. Before anything, if everyone could please do me a favor, please like the video, share the video, and if you haven't done so already, please subscribe to the channel. It greatly helps with the algorithm. So the first update, oh, by the way, just to give you in terms of what to expect tonight, formatting, I'm going to be going over a couple of articles for the Robert Brooks defendants and the Messiah Nantwi defendants. After that, I am going to be showing a quick video on the Robert Brooks update in terms of what occurred. That's going to be about a minute to a minute and 15 seconds. And then lastly, I'm going to actually play for you the video and audio of the court appearance of Michael Fisher and Matthew Galliher. So that court appearance, you will see that here tonight. The audio is typically very, very poor on this. So I had to really do some changes and do like a boost to the audio. So hopefully you'll be able to really hear the audio is garbled. Give me 1 second. Let me see if I can change this. Okay, people, how's the audio now? Is the audio better? Do me a favor, give me put a yes in the chat if the audio is better than what it was before. If the audio is poor, but no. Okay, so I'm seeing the audio is pretty okay. Okay, let me see what I can do here very quickly to correct this. Sorry about the technical issues. Struggle streaming already. Okay, guys, any better? Audio better? Yes, no, maybe so. Better, but still bad. Okay. All right, let me see if I can do one quick thing to correct this. Give me 1 second. Okay, we are back. Audio good? Let me know. Give me a yes if the audio is good now. Would appreciate that. My connections. If this doesn't work, I'm afraid I'm gonna have to call it quits tonight. Okay, so Caterpillar Girl says yes, yes, yes. I'm getting yeses all around. So the powers that be do not want this live stream to occur. But guess what? The news has to be advertised. People need to hear what occurred today with the Robert Brooks murder case, the defendants, and also with Messiah Nantwi. I haven't done a video or live stream on Messiah Nantwi, but we have some updates here tonight. So again, I'm gonna imagine people did not hear me before. I'm gonna give you the structure of the evening, the structure of the live stream. I'm going to be reading to you and showing you a couple of articles, one involving the Robert Brooks case, the other involving the Messiah Nantwi case in terms of a defendant who pled guilty today, David Ferrone. And then in terms of the other defendants in the Robert Brooks case, I'm going to be reading an article as well. After that, I'm going to be showing you a video. It's about a minute to a minute and 20 seconds long. It's summarizing because I know many of you are very visual. You like to see videos. So I'm going to play for you a video that summarizes what occurred in court today because some very important things happened in the Robert Brooks murder case, more specifically with Matthew Galliher. Okay. Then after that, I'm going to be playing for you the full audio video of the court appearances by Matthew Galliher and Michael Fisher. That's going to be about 25 minutes long. Typically, the audio is very, very bad for these court hearings. Behind the scenes, I went ahead. I did an audio boost, so everyone should be able to hear it. I won't be giving commentary during that video. I'm going to let it play so that people can really hear what's occurring. I won't be adding my commentary. My commentary will be during the article reading. So, with that being said, if everyone can please do me a favor, please like the video, share it, comment below. Thank you for everyone who put up with my struggle streaming. Thanks for that. I really appreciate it. And if you haven't done so already, please subscribe to the channel. Uh, this news of what's occurring in the New York State Department of Corrections is not really heavily televised. So this is really up to you to spread the word, to share this, and not only my content, it doesn't have to be my content. There are other content creators talking about this, reporting on what's happening with Messiah Nantwi and Robert Brooks. Please share their video, if not mine. Okay, so let's move on. I'm going to share with you the first article and a special big up to Sean Mills with the Rome Sentinel. I'm going to be reading his article regarding what happened today with the defendants in the Robert Brooks case. So I'm going to pull it up now. Give me one sec. Okay, here we go. So Marcy CO granted separate trial in death of inmate Robert Brooks. And again, the author is Sean Mills, a staff writer with the Rome Sentinel. Here we have Michael Fisher, 55, appeared in Oneida County Court Wednesday morning and was granted his own separate trial on his manslaughter charge in the beating death of inmate Robert Brooks. One of four Marcy correctional officers scheduled to go to trial next week for the beating death of inmate Robert Brooks has successfully argued to have his case separated from his co-defendants. Michael Fisher will now likely go to trial alone in January. And for those not following what's been occurring, several of the defendants had put in motions in an attempt to get their trials separated from the other co-defendants. Michael Fisher was actually successful in separating his case from the four four remaining co-defendants, actually three remaining co-defendants outside of him. Fisher, 55, appeared before Judge Robert L. Bauer Wednesday morning, October 1st, to argue several last-minute defense motions ahead of trial. According to defense attorney Scott W. Eisman, one of those motions involved a change by the special prosecutor's office of the theory of the case against Fisher. Of the four defendants scheduled for trial, Fisher was charged with manslaughter, while the other three are charged with murder. Quote, the people changed their theory of liability for Mr. Fisher. The indictment clearly articulated that he was only charged as an accessory, not a principal, and there are different standards under the law for that, Eisman stated. He said the special prosecutor filed the new theory on September 22nd. So very quickly, for those of you not familiar with defense attorneys and how this works, the defense has time to prepare their case, to prepare their defense of this. And at the last moment on September 22nd, the office of the special prosecutor filed a motion in terms of their changing their theory and their theory of liability from Michael Fisher. And because that was done, this is allowing the defense to have their trial separated from the others. So let's continue on with the article. One of the remedies for a late amendment is to give us more time to prepare against this additional theory of liability. Prosecutors said multiple correctional officers at the Marcy Correctional Facility beat inmate Brooks to death inside the prison infirmary on December 9th. According to the indictment against the COs, Fisher is charged with second-degree manslaughter for being in the infirmary and in the doorway, watching the attack and doing nothing to stop it. Judge Bauer ruled that the prosecutors have a right to change their theory, that there were due process implications of the people's very late amendment, and that, quote, does warrant the adjournment of the trial. A new tentative trial date has been set for January 12th for Fisher alone. He will next appear in court on December 19th for a pre-trial hearing. Quote, our theory has never changed, contrary to what was said in court, said Special Prosecutor William Fitzpatrick. Quote, we had three defendants remaining who are charged with murder. Mr. Fisher is charged with failure to abide by a duty and is charged with manslaughter. So the judge is concerned about a jury lumping them all together and perhaps not individualizing Mr. Fisher. Before the motion argument, Fisher also rejected a new plea deal of 1 1/3 to 4 years in state prison if he would plead guilty to criminally negligent homicide. Now, again, this is very important. I'm going to read this over. Before the motion argument, Fisher rejected a plea deal of 1 2/3 to 4 years in state prison if he would plead guilty to criminally negligent homicide. Now, you guys let me know. Do you think this was a bad move of rejecting the plea deal, of facing, pleading guilty and having to do 1 1/3 to 4 years in state prison, because Michael Fisher is going to be facing a lot more time if he gets convicted of this. Fisher faces 5 to 15 years in prison if he is convicted of manslaughter. So obviously, Michael Fisher is rolling the dice. He feels he may have a strong defense. He, as of today, got the motion granted of having a separate trial. So this might be helpful to his case. It may not. I don't know. But let's continue on. Also on Wednesday, co-defendants Nicholas Keeper and Matthew Galliher appeared for motion argument. Judge Bauer denied their motions, and both men are still scheduled to go to trial on Monday, October 6th, alongside fellow co-defendant David Kingsley. So again, Nicholas Kiefer, Matthew Galliher, and David Kingsley, their trial will be on October 6th. As of now, those three defendants are going to trial together. Michael Fisher is separated. Kiefer also rejected a new plea deal of 8 years in prison. He faces 25 to life if convicted of murder at trial. And that is the end of this article. We actually had a question I'm going to pull up from Caterpillar Girl. Are they still out of jail? Yes, they are still out of jail. Also still out of jail, Anthony Farida, who pled guilty, who will be doing 22 years in prison. He is free until his sentencing, which occurs, I believe, in December. Okay. So yes, these men are out of jail. They're out of jail. Chris Milkey says this is bullshit. I understand what is going on. Not good separating charges, all of them. First degree murder under the color of law. Are you serious? So, yeah, this is definitely dragging out. This is taking a lot of time. So, I want to go ahead and show you a brief summary in the Robert Brooks case of what occurred today. So, I'm going to pull that up now. All right, this is clip number 1 from CNY Central. Here we go.
Corrections officers Matthew Galliher had several motions denied by the judge. One of the requests from his attorney was for the prosecution to be unable to narrate over the body cam footage showing the beating of inmate Robert Brooks. This was denied along with several others. He is charged with murder, facing life in prison. His trial is set to begin on Monday. Michael Fisher, the only one of 4 COs going to trial not charged with murder, was granted a separate trial today. Fisher is charged with manslaughter and faces 5 to 15 years in prison. Special prosecutor on the case, Oneida County DA Bill Fitzpatrick, wanted to try all 4 together, but said he respects the judge's decision. His trial is set to begin next year on January 12th. He is due back in court for a pretrial hearing on December 19th. And the last to appear in court was Nicholas Kiefer. He turned down a new deal that offered even less jail time. He rejected an offer of 8 years in prison to plead down to manslaughter charges. He will now go to trial for murder, facing life in prison, along with David Kingsley and Matthew Galliher. That trial will begin on Monday.
Okay, so we have 4 defendants going to trial, 3 of them going to trial on October 6th. Michael Fisher, the 4th remaining co-defendant, he is going to trial in January. He is going to be going back to court in December for some more pretrial motions. So I want to shift the focus now, and let's move on to Marcy and Nantwi. There are some updates with those with a defendant in the Marcy and Nantwi case. I'm not very thrilled about what happened today in court, but that's my opinion. You let me know how you feel about this plea deal. I'm going to pull this up now and tell me your thoughts, because I'm very not happy with this plea deal today. So here we go. Mid-State CO admits to phony knife conspiracy in Nantwi murder case. Former Mid-State Correctional Officer David Ferrone, Wright, admitted in Oneida County Court on Wednesday to being part of a plan to lie about a knife being found in the cell of inmate Marcy Nantwi, who was beaten to death. Just very quickly, and I'm going to continue to say this because this is a theme. When you find or you discover these cases of individuals being beaten, you find the use of force, you find lies, you find statements stating that the incarcerated individual attacked the correction officer, and frequently it is common for correction officers to plant weapons in the cells of those individuals and on the person of those individuals. So here we have direct evidence. We have a plea deal, a plea bargain of this individual engaging in the conspiracy to cover up the crime and being a part of this bogus, knife in Messiah Nantwi's cell. Let's continue on with the article. A fifth mid-state prison correctional officer has pleaded guilty for his role in the alleged cover-up following the beating death of inmate Messiah Nantwi. David Ferrone, 36, pleaded guilty before Judge Michael R. Nolan in Oneida County Court Wednesday morning to one count of tampering with physical evidence. Ferrone accepted a plea deal of a 3-year conditional discharge, and he agreed to cooperate with prosecutors for the upcoming trial of his co-defendants. Ferrone's case was adjourned for sentencing to December 15th. So very quickly, David Ferrone, 3-year conditional discharge. That means that if he stays out of trouble for 3 years, he does not have a criminal record. So this is very disappointing when you have a correction officer involved in a conspiracy post-murder to cover up multiple crimes. He's not doing any jail time whatsoever. If you guys think this is fair for David Ferrone to get a 3-year conditional discharge, right? Yes in the chat. If you think this was not fair, write no in the chat. For me, I'm absolutely disgusted that he's not even getting a slap on the wrist. He's not doing any sort of jail time. 3-year conditional discharge. This is unacceptable in my eyes. Unacceptable. Prosecutors said inmate Nantwi, 22 years of age, was beaten to death at the Mid-State Prison on March 1st after the prison's corrections and emergency response team, CERT, was called to assist with a dispute. After Nantwi was taken to a local hospital, prosecutors said the COs worked together to try to cover up or justify the attack. Now, we previously heard about the infamous meeting at a diner called Raspberries. Ferrone admitted Wednesday to being involved in the conspiracy to claim a makeshift knife had been found in Nantwi's cell, thereby possibly justifying the attack. According to the indictment, Ferrone was caught on a body-worn camera discussing the weapon with a co-conspirator and then uttering an expletive when he saw the camera. So basically, these individuals are just so ignorant and stupid, pardon my language, that they did not even know the body cams were on, recording. And when Ferrone discovered that the body cam was on, he starts cursing. So imagine that visual and that audio of the camera. David Ferrone turning to the camera and just seeing that it's actually recording, and the conspiracy is caught on camera, caught on tape. Let's continue on with the article. Also on Wednesday, co-defendant Francis Chandler appeared in court and requested more time to consider his plea deal. Chandler's case was adjourned to October 16th. 7 correctional officers in the Mid-State Prison case are still headed for trial, tentatively scheduled for January. And that is the end of this article here. So there you have it. David Ferrone, no jail time, agreeing to attempt to cover up the crime, gets 3 years conditional discharge, no jail time whatsoever. And after those 3 years are up, he has no criminal record. So that's very disappointing. I'm not very happy with this plea deal. He should have received some jail time for covering up this multiple crimes here. So what I want to do is give everyone the opportunity to watch a portion of the case today. I'm going to be showing you court video Matthew Galliher and Michael Fisher. Matthew Galliher's appearance in court today was about 15 minutes, and Michael Fisher's appearance was about 10 minutes. So I'm not going to be giving you any commentary. I'm going to play this. The audio has been boosted. So one thing I will say is that what you should do, if you have headphones on, is put the volume low and then turn it up at your leisure, because the audio might be very loud. Again, this is my attempt to boost up the audio because the court audio is very, very low. By the way, is my audio still good? Can you guys write CC if the audio is still good? You guys are able to hear me clearly and there's no issues. Just type in CC. Type in double C for me. I would greatly appreciate that. So I'm going to go ahead now and play the court appearance today, Oneida County Court, Matthew Galliher, followed by Michael Fisher. So again, I won't be giving any commentary. I'm going to come on at the end. I know many people don't, some people don't want commentary, so I'm going to do a combination of commentary, but in this case, I will be playing you the video uninterrupted, and I'll be coming on afterward. Okay, here we go.
As we understand it, the commissioner's brother, and under People v. Green and Coleman, Coleman is the Court of Appeals. Cross-examined under Green, witnesses' bias can be used as for cross-examination, including using collateral documents. That's People v. Green. And bias in the Court of Appeals decision in Coleman at 37 New York 2nd, 137. Says that bias includes familial relationships, so we would request the right to cross-examine the Marcello brother with the lawsuit against Marcello, the commissioner. The second item is the narration of the videos, and that's barred in several respects. People v. Rossi, which I cited, which talks about opinion evidence as to what a video appears to show. And that was actually an assault as well. It was found to be a reversible error. I know that the government did that in the grand jury, and we raised it there, but we're raising it at the trial to preclude any of the witnesses. And there's several witnesses, I believe, from the order of proof will be testifying about the events that day. That, of course, they can testify as to what they did and what the operation of their minds were, but not what they observe other people doing on the video. They can say what happened independent of the video. For example, they can say they did this or they did that or they saw something, but they cannot testify as to being shown the video and saying, here's what's going on the video. In the same respects, they can't express their opinions as to, on the ultimate questions of fact, to the extent that intervention is going to be a question of fact. They can't say, oh, that's so-and-so not intervening or not moving up when they're supposed to. That's opinion evidence, and that's not permitted as well. I'll skip to my last one, which is Bruton. I understand that the government, at least at this stage, is not introducing any of the co-defendant's statements, but I do want to rule on Bruton that they can't in case that does come up during the trial. And then I want to spend more than a couple minutes on my third point, which is the intervention. And I've raised it before, and Your Honor's addressed it before, but it's in a different context now. And it does require some of what I've already argued. So when the legislature adopts a criminal law, there's New York bodies and people and lawyers statewide, they have a direct participation in that process. It's not done haphazard, and the consequences are understood by the legislature when they do that. There's debate on the criminal laws, and sometimes takes years to decide whether to pass legislation. And legislation has to be well defined with definitions, and it's got to be clear, and it's got to be not vague. There's two houses, over 100 elected representatives have a voice in the final product, and as does their extensive legislative staff, the members, lawyers, policy people, constitutionalists, and they're all conditioned on developing a law, especially a criminal law, in order to hold someone responsible for criminal behavior. And they incorporate the views of their constituents and their lobby groups and their own views, and in the end, a proposed law that the governor then with her staff decides whether to sign and make law applicable to proceedings such as this. Directive 4944, which the prosecution has been relying upon, is, well, you can call it anything you want. It's identified as a directive, but in the description of it, it's called a protocol and procedures for docs. And it appears from Your Honor's decision that it's being treated as a law. When we leave decisions on the text of a criminal statute to a bureaucracy, which the docs is, and I'm not saying that in a negative term, it's a bureaucracy. It's an Albany-based organization. And we call protocols, we start calling protocols criminal laws, defining criminal behavior. The end result lacks the practical and constitutional details of criminal pronouncements and law. I know that's a mouthful, but it also takes into account when the legislature passes a criminal statute, they're taking into account definitions and other laws. And the New York State legislature has addressed this exact law and has decided not to pass the law at this time. It's chosen not to pass it. Maybe they'll pass it at another time, but whatever it has reasons. They believe at this point in time they have not got it right, and they spent 4 sessions of the legislature trying to get it right, because the consequences of creating a criminal law have significant consequences to people besides the one person that it's being applied to. And here it's being applied to Matt Galliher.
Well, let me stop you there for a second. Isn't this issue really more applicable to some of the co-defendants than your client? Some of the co-defendants are clearly charged exclusively for having had a legal duty and omitted performance of that duty. Your client is charged with affirmative conduct, albeit with omissions of duties.
He's charged with failure to intervene, Your Honor. I quoted it. He might also be charged with affirmative conduct. He's charged with putting shackles on Mr. Brooks, and he's charged with pulling him up on the gurney.
But isn't that
That's his affirmative acts.
Yes, affirmative acts.
Right.
As charged there, and while they make reference to omissions, don't those ultimately go toward his mens rea of his intent as to manslaughter first, as to the creative indifference, as opposed to those that are charged under the manslaughter second, in which they're expressly charged with having failed to engage in a duty, purely charged based on omissions.
If the government is going to withdraw any allegation that Mr. Galliher failed to intervene, is they're going to go on the singular theory that he engaged in affirmative conduct, then we can end this debate right now, but I don't think they're prepared to do that. They haven't done it in all my motions and applications.
You've made applications in which you're asking me to preclude them from offering evidence of the defendant's duties, which I think is relevant and fair game to the extent it would go towards, again, his mens rea, his intent, or that with respect to depraved indifference. So I would permit that, but I don't know that it necessarily implicates a separate theory. Mr. Fitzpatrick.
Judge, you are correct. I don't mean to cut Kevin off, but
it just may help clarify the issue.
Manslaughter in the second degree against Mr. Fisher, the duty or the failure to intervene is the crime.
Right.
That's not true with Mr. Galliher. It's an element of his depravity, as the indictment reads, that they did nothing to restrain each other, did not get medical assistance, and let the beating continue.
That's as I understand it. Does that clarify the issue for you, that Mr. Program?
It clarifies, but it makes no difference in my argument whatsoever. If they're going to be read that Mr. Galliher had the duty to intervene, and that his failure to act on that duty to intervene results in criminal liability on his part, then my argument doesn't change whatsoever.
I'm not seeing it that way. I believe Mr. Fitzpatrick is on the same page that it is relevant evidence as toward his mens rea under those affirmative acts that he's charged with, but it's not in and of itself a separate theory of prosecution. Do I have that right?
I believe you do.
As against Mr. Galliher.
As against Mr. Galliher. The reference,
the man too.
yeah, the reference is, in addition to the beatings, this is from count 1, in addition to the beatings, defendants with depraved indifference did nothing to restrain each other, did nothing to stop the beatings, and failed to immediately order medical assistance from Mr. Brooks. That's not the indictment, that's an element of the indictment. Or the count.
I understand. I think my argument was reinforced by what Mr. Fitzpatrick submitted as what he wants the jury charge at the beginning of the case, that he wants duty to intervene described at the beginning of the case.
For the appropriate defendants, which I understood to be, in this case, the one remaining, Mr. Fisher, who's charged expressly with having omitted a legal duty.
Yeah, I didn't read it that way, Your Honor, and I didn't read the submission that way.
That's what it says. That's how.
Well, I don't believe that the duty to intervene should be used in any respect, including with respect to the directive that's going to be read. The directive should not be allowed, to the extent that the directive is law now, it's being portrayed as law, and it is being portrayed as law, then that cannot be read to the jury, cannot be shown to the jury during the course of the case.
Your objection will be noted, but I think you're conflating two different issues.
Well, and there's also no definition for intervention whatsoever, Your Honor. There's no, what's the intervention supposed to be? How's Mr. Galliher to know that if he fails to do something called intervention, that he's going to have criminal responsibility? How's he supposed to know that if there's no definition of intervention? There is no definition.
Again, I think we're talking past each other here. You're suggesting something that would in and of itself constitute a legal theory for prosecution, as opposed to evidence of the defendant's mens rea with respect to those charges for which he's accused of affirmative conduct.
Is Your Honor's intention to separate the duty to intervene insofar as you described it as applicable to Mr. Fisher in instructions to the jury as relates to Mr. Galliher? Okay. Well, I'm not withdrawing my arguments, Your Honor, but I'm going to leave the arguments right there.
Mr. Fitzpatrick, did you have anything you wanted to add beyond the papers that you had submitted?
Only on the issue of narration of the videos, Your Honor. As you know, there is no sound on the videos. Several witnesses will be asked to describe what was being said and by whom. In addition to that, the cooperating witnesses will be asked to identify who is in the video. That's not a narration. That's Officer so-and-so. I've worked with him for 10 years. I know him personally, and that's him in the video. There may be references to what exactly is happening at this moment. That's Officer Galliher placing leg restraints on Mr. Brooks. No one's going to say that's Officer Galliher with depraved indifference and abject cruelty restraining a helpless human being who's being beaten to death. I'll take care of that on summation. And so far as opinions, Mr. Rubin and I agree on that. I think we'll rely on our papers on the other matters.
And I will have another matter too.
Oh, yes, go ahead, Mr. Rubin.
Yeah, in the discovery, there's a syllabus related to the training received by the officer during use of force. And the syllabus refers to a video that was shown to the officers. It says a 79-minute video. I inquired with the government yesterday if they have that and if they're going to get it. I just conferred for a moment. They say they do not have the video. We're going to get the video independently. In fact, one of my co-defendants may already have it. And I intend to disclose that as part of our duty to present evidence. I don't want to be precluded in using it. It's a reference. We thought it should be in the discovery, but then it's not in the discovery. So,
okay. I appreciate letting me know that. I prefer to hear about these issues in advance.
Yes.
Did you have anything else?
No, that's it.
Then as to the defendant's motion regarding questioning about a related civil suit, the court will permit limited questioning of Christopher Marcello as to his awareness of suit against, I'm taking you on good faith, telling me that he's the brother of David Marcello. That is in fact the case. You may inquire as to the general nature of the allegations, the witness's awareness, and whether that has any bearing on his testimony, but do bear in mind that questioning will be limited and will not be a complete rehashing of the civil complaint. The defendant's motion to outright preclude testimony regarding the video evidence is denied. However, that is with the expectation that the people will avoid improper narration testimony. The court will address objections as may be appropriate depending on the witness, the questions posed, and the testimony. The defendant's motion to preclude evidence of the defendant's duties is denied. The defendant's motion to preclude evidence of co-defendant statements that implicate Bruton in any way is denied at this time, but with leave to renew should the people fail to abide by their assurance to altogether avoid the same. Is there anything further from either side? Mr. Fitzpatrick.
No, Your Honor.
Mr. Woodard.
No.
See you all back here Monday morning, October 6th at 9:30 a.m. We'll be in the ceremonial courtroom across the hall.
Yes, Your Honor, and actually, if I could raise a couple things. I understood we're going to be showing how work with the technology there this morning and the layout of the courtroom.
Yeah, you're welcome to check the courtroom out and utilize the tech equipment over there.
And just in connection with the presentation of our cross-examinations, will we be permitted to organize among ourselves the order of cross-examination, or will we be down to the caption?
I will, if you work that out amongst yourselves, I'll honor that. If you cannot come to an agreement, then I'll impose an order for you.
Okay. And Your Honor, what's your rules on straying from a podium in the courtroom?
I'm not going to tie you to the podium, but don't get silly about it either.
Understood.
Okay.
Thank you, Your Honor.
Michael Fisher.
This is the matter of the people against Michael Fisher, indictment 25035. This matter's calendar to address a number of motions brought by the defense in advance of Monday's scheduled jury trial. Before I get to those motions, however, I know there's been some additional conversations between the parties and the proposal to potentially resolve the charges, so let me go over that with you, Mr. Fisher. My understanding is the people have proposed you could plead guilty to a reduced charge, a felony offense, criminally negligent homicide, and they would then recommend a sentence of 1 1/3 to 4 years in state prison, along with mandatory state surcharges. However, neither they nor the court required a waiver of appeal in that case. Now, we've talked about this before. If you're convicted of the charge you stand charged with here by way of this indictment, manslaughter second degree, you could face as much as 5 to 15 years in state prison. Understanding your exposure, you will not see an offer this favorable again as we go forward. You want to turn that offer down. Mark the offer then as rejected. We can proceed with addressing the defendant's motions. I did receive your written motions, Mr. Eisman. I've also received a response from the people. Is there anything you wanted to say in furtherance of those?
Before we do, Your Honor, I just want to note that I was able to conference with Mr. Fisher regarding that plea offer, shared with him my advice and an anticipation of a potential revised offer. We had numerous conversations leading up to today about the plea offer and that contingency. So that decision of his is made with my support and my advice, Your Honor. As for the motions, I made several, Your Honor, and where we had left things last time had to do with the bill of particulars issue. And that's where I wanted to begin. And I'll largely rest on my papers. The one thing I wanted to point out about the people's opposition to my motion to strike the bill of particulars, my motion to strike their supplemental bill of particulars or amended bill of particulars, was that there appears to be no reason why the people waited 7 months to make this amendment to the bill of particulars. There's no good cause for it. They just did it. And up until the morning of the 22nd, the only fair reading in the people's mind of the indictment and the bill of particulars for Mr. Fisher was an accessory theory of liability, and then that changed 3 weeks before trial. And there's no reason for that. More importantly, the prosecutor doesn't get to decide what is returned in the indictment. That's up to the grand jury. And the CPL 270 subsection 2 provides that an indictment may not be amended in any respect which changes the theory of prosecution as reflected in the evidence before the grand jury which filed it. And what people have done is there's an indictment that was returned by the grand jury, and they have now constructively amended it by adding a principal theory of liability. Now, there is ample case law from the Court of Appeals on down that says that there is no difference in liability for principal versus accessory liability, which we acknowledge. There is a difference on how you get there, and the people have limited, prior to the 22nd, limited themselves to just an accomplice theory of liability and then changed it on the 22nd. And we don't think that that is appropriate. It's a constructive amendment of the indictment, and it should be precluded from doing so. I don't have much more to add on severance until I heard the argument with Mr. Louis, Your Honor. And I believe that this issue of the duty to intervene, because Mr. Fisher is in the unique position that he is in, both the charging theory is particularly novel for him as it applies to him, on this omission-based theory of prosecution. So I want to make sure that the record is clear that we join Mr. Louis' arguments. He's been taking a laboring oar on that argument, but we join everything that he said. And the fact that Mr. Fisher is going to be broken out and treated differently in front of the jury, I think, compounds the issues of confusion in front of the jury and requires an independent basis for severance. Your Honor, I made several other motions. I can rest on my papers for those or answer any questions that the court has, but I'm otherwise satisfied with my submission at this point.
Okay, that's fine. Mr. Fitzpatrick or Mr. Hudson, was there anything that you wanted to add beyond the papers you had submitted?
Just briefly.
Right.
First and foremost, I do want to clarify, and I believe we already did in our motion response, Your Honor, but the discussion that Mr. Eisman and I had over email referred only to the bill of particulars. It had nothing to do with the indictment whatsoever. So the continued allegation that we were conceding that the indictment itself could only be read as an accomplice liability theory is frankly disproven by Mr. Eisman's own exhibit. But that's really aside the issue. The fact of the matter is we are entitled to amend our bill of particulars at any time for any reason, as long as we don't prejudice the defendant in any way. In this case, our theory of the case has been incredibly consistent from the moment Mr. Fisher was indicted. He is charged for failing to act under a duty of care. And again, how we parse that out, as for principal or accomplice liability, that can be a little complicated, can be a little murky. All we are trying to do with our bill of particulars is to continue to clarify that position. I would also note, though, that to whatever extent the charging of Mr. Fisher as solely an accomplice is a particular sticking point with Mr. Fisher. And again, we addressed this in the papers, but there's case law out there that does affirmatively say failing to act when you have a duty to act can be an act in furtherance of acting in concert. So again, ultimately, our theory of the case remains the same. And there is no demonstrable prejudice that Mr. Fisher can demonstrate based on this. And similarly, at no point have we affirmatively limited ourselves to accomplice liability before the September 22nd bill of particulars. And as far as severance goes, Your Honor, while we understand that Mr. Fisher's theory of prosecution is novel, that's not a basis for severance either. It's got to be prejudice, and that prejudice has to be pretty significant, especially in a case like this, as involved as it is, as heavy as it is. Just the fact that there are some wrinkles to Mr. Fisher's case, there's wrinkles to Mr. Kingsley's case, there's wrinkles to Mr. Galliher's case. Every case will be unique. So that alone is not an issue supporting severance. Regarding his other issues of severance, we would rest on our papers, Your Honor. I would just, again, stress that most of his practical concerns could be addressed through either accommodation or a proper limiting instruction.
All right, thank you, Counsel. So then, as the defendant's motion to strike the People's Amendment Bill of Particulars, you have a right to amend. That motion is denied. As the defendant's motion to dismiss count 5 as against defendant Fisher, That motion is likewise denied. The court finding that there are due process implications of the people's very late amendment of the bill of particulars, however, does, I believe, warrant an adjournment of the trial as against the defendant Fisher and Fisher only. Will therefore reschedule Mr. Fisher's case. I will reserve decision as to the defendant's remaining motions until we get closer to trial time. Mr. Eisman, I would suggest, because of the amount of time involved to try the matter, the next available date would be January 12th. Any issues with that?
I don't believe so, Your Honor, just check that.
That's fine. So January 12th, 9:30 a.m. as jury order number 1, and I would prefer to get everyone in before the holidays, so I'll set a final pretrial conference date. You make it in on, say, December 19th.
Yes, sir.
All right, December 19th, 9:30 a.m. for a final pretrial conference, the matter to be tried January 12th. Mr. Fisher, that's when I next need you back here, sir, December 19th, 9:30 a.m. I'll see you back then.
Hello, everyone. So you just witnessed seeing the two defendants in court today, Michael Fisher and Galliher. So I'm going to end the stream on this note. Again, I want to thank everyone for being here. Please like the video, share, subscribe to the channel if you have not already. And as I say in all of my videos, my goal is to go deeper than what the mainstream media is telling and sharing with you. Everyone, take care, God bless, and I will see you next time. Bye-bye.